and such strong membership. And thank you for letting me present this bill to you today. I bring to you Senate Bill 159. It is an economic development issue. It is brought to you by me. Department of Economic Development has nothing to do with this. This was created by the knowledge I have of the state being behind the 8 ball, or having our hands tied behind our back, when negotiating and recruiting business and industry to the state. We have taken, in the substitute that you have, we've taken the locals out, just to make sure that everybody's more comfortable with that.
Senator, pardon me just 1 second. I want to make sure everybody's on the same page, literally on the same page. Do you have the LC number in front of you?
Yes, sir. LC 352211S.
Everybody got that? 352211S. Thank you.
S is in sensation.
Thank you, Mr. Chairman. Continue.
And in our effort to recruit business and industry to Georgia, we're somewhat hindered. Georgia and West Virginia is the only two states that are east of Mississippi that have such laws that our competition can see what we're doing. And therefore, our efforts to recruit business and industry, they are somewhat reluctant to even come to Georgia because oftentimes their trade secrets are just in the window for everybody to see. This bill helps conceal that, or help the company feel more confident that their trade secrets would be somewhat concealed, somewhat in security. And this can only be achieved by the state's involvement into that issue. Senator, how did that last bill come out? Thank you. And I'll give you some examples that, because often the press who have sensationalized this, and I would never mention Mr. Galloway's name, my good friend. He mentioned mine, so I thought that was a quick pro quo there.
You will now.
Anyway, but I do like Mr. Galloway and respect him. To give you some examples, the NASCAR Museum several years ago, Atlanta would be raising the stakes, and every time they do, North Carolina would ask for an open record to find out what they were doing and raise it a little higher. So we lost NASCAR. Volkswagen, anybody hear about Volkswagen? Well, they were looking at Georgia until Georgia offered perhaps some level of support. Tennessee saw that we were doing, and now guess what? Volkswagen is in Tennessee. There's so many numerous occasions that that's happened. I've got a whole list of them, but I know we're trying to push through the day here, so I will not go over those. But all it is for the companies that we're trying to recruit to Georgia to feel more secure that their trade secrets are not exposed to their competition. And by doing that, we feel that they give a better look at coming to a great state to do business, to grow a family, to raise a business. Be glad to answer any questions.
Or grow a business and raise a family.
Yeah, I'm glad you said that. I've had to come up those steps, and they've really struggled.
That's right.
I've struggled with that.
We do have some questions. Senator Miller. Frank.
Thank you, Mr. Chairman. On C, line 14, can you give some examples of the nonprofit organizations that you're exempting from this, what we're talking about here?
No, I cannot. That is the way we drafted the bill, and I'm sorry. I know that's not a good thing, but I'm sure somebody behind me can.
Yes, if somebody, I just wondered, because we get more than a third of their funds.
You know, I'm one of the various, but I can't. Chambers of Commerce and other functions like that, other organizations like that. Red Cross, perhaps, Chambers of Commerce, Economic Development Authority.
Well, okay, that's my question then.
Well, Economic Development Authority is not a nonprofit, so they would not be in it.
A local Chamber of Commerce?
Yes. If they're a nonprofit, if they're set up that way.
Yeah, I assume they are.
Do we have any other questions? Senator Gooch.
At what point do this information become public, Senator Moss?
Well,
Once the decisions are made, do they declare all the
I would suggest that a few years ago, like the Cox industry, the Cox company that was looking at relocating, that information didn't come to the public until after their deal was made.
Right, but once the decision's made.
Yeah, absolutely. And Senator Good, such a great question. Let me suggest to you that nothing can be talked about, nothing can be discussed, nothing can be offered than what's already legally available in the codes of Georgia that we have set, that our predecessors have set. That's all. Nothing. And we're talking about jobs here too. I know that's a good excuse for anything here. We talk about a lot, but we are. Living next to Tennessee, we only get the crumbs that they don't want because of our lack of ability to conceal trade secrets for companies that are somewhat interested in your area.
And I think, Senator, too, that this is an issue we took up several years ago, if I remember correctly.
Right.
And as was the case then, any potential project that may be coming into your backyard, so to speak, is still going to have to go through all the proper permitting issues, and EPA, EPD, county
Zoning.
commission, zoning, city council. This has nothing. This does not affect that in one.
Mr. Chairman, and I can understand why you're chairman of this committee, because absolutely, that has nothing to do with it. Those processes are still publicized and still have meetings, public meetings to make those decisions. And it has nothing to do with the nuclear waste that some editorial gave me. It has nothing to do with the landfill that some editorial, some newspaper. In fact, I think it's clear to understand. The opposition is the media. Let me tell you, I have introduced this bill. I was sponsored this bill 4 years ago when it came over from the Senate House. House Bill 218. I've got a T-shirt made over it. I renamed my door on my office 218 because I couldn't understand the opposition. But out of all that opposition, the only opposition I have is the media. I have not had one phone call. I have not had one email. I have not had one letter. I have not had one fax. I have not had one visit. I have not had a smoke signal against this issue except by the media.
Thank you for answering my question, Senator. Senator Stone.
Thank you, Mr. Chairman. Mr. Mayor, I just want to again, I think, emphasize part of this is at the time the private person or entity responsible for economic development project announces to the general public the project or business related to there will be retained, expanded, or located in the state, or that such proposed project has been terminated. And the records containing the identity of the private person or entity and the terms and conditions of such project shall be a matter of public record.
Thank you, sir.
Which is making your point that we do have a code section on what we can and cannot do to incentivize folks to come to the state. And once that decision's made, it becomes, in a sense, once something's completed, it becomes a public record. Or if we decide to terminate, it becomes a public record. So at the end of the day, the public knows what has occurred. I think all of us who serve in public office understand that once something's public, if you're going to do something, you can have folks may not like what's done. I guarantee you're going to hear from them, and you can always go back and change your mind potentially if the public doesn't like what's been done at that point. So I think at the end of the day, this will be a matter of public record based on the way I read this.
And Senator, again, the state has to ordain this as a state project. The locals cannot do this, and that's again to keep the public from being suspicious of some, as they may say, brother-in-law deal. Because this is not for that, nor will it be accepted in this bill for that. So thank you for that question. Thank you, Chairman.
Senator Davis.
Thank you, Mr. Chairman. To the distinguished transportation chairman, and it may be something, Chairman Chance, that we want to get lay council's input on. But in section 1, line 10, I'm concerned about the language where we use the term, and Senator Miller has asked a similar question. We use the term government agency versus, in my head, entity. By definition, and I'd like to get a legal opinion on this, agency suggests that it is an arm of government or someone working on behalf of government. When I think about nonprofits, using the example perhaps of the chamber, and I don't know this to be true, but in my linguistic mind, I'm thinking entity may be more appropriate. I see that same term used in paragraph 2 of where we use entity as opposed to person and agency. I'd like to get some clarification on that.
Senator Thompson, you are the ranking attorney on this committee. I don't know how we allowed you to slip through and get on this committee. But we're glad you're here, since I don't think we have any other attorneys other than my counsel, and she kind of gave me a face. So, I mean, I'd like. Oh, I'm sorry. I'd like. I mean, what? I mean, I don't have a. I don't think it changes.
No.
You know.
I'm all very open. The concept is what I'm looking at, not the details.
I mean, your question.
My question is the term government agency versus government entity.
I mean,
Agency, again, in my mind, is someone, it is an arm of government, as opposed to a looser term, government entity. There are entities that are not necessarily funded or run by government.
I believe agency is the one that we use in the code. Now, at the federal level, those do have distinctly different meanings. They've got, because you can have the Postal Service or NASA, but I'm not aware. I mean, we always use, Mr. Chairman, we always use, and I defer to legislative council, but we always use agency. Now, maybe we shouldn't. But at the federal level, they do have distinctly different meanings. But government entity is actually the government, meaning the Department of DHR, for instance. Whereas an agency would be Department of Family and Children. I'm not sure if the service is.
Well, one
I mean,
point.
I would give that distinction.
Well, one point in looking at this.
I'm not sure we do that in our code.
It says, as used in this subsection, the term, quote, government agency means. So, I mean, we're defining it. Are we not?
Yeah, that's what I think.
I mean, again, that's the way it's done in other areas of the code, having had to be on House judiciaries.
And Mr. Chairman, if whatever's in line A or line 11, if that's not what Senator Davis is agreeing or disagreeing that the government agency should be, that's where a change probably could be made, if that's the case.
I'm not disagreeing with what's there. I'm just questioning the clarity of what's there.
Senator Stoner.
Mr. Chairman, maybe the term we're using, I'm reading this paragraph, as except as provided in this paragraph, this is line 20. Information relating to a private person or entity's economic development project. When we say entity, are we referring, I'm not reading that as the government as the entity, I'm reading to it as an entity's economic development project, as designated by a government agency.
Basically like the company
That's
we're
my question.
recruiting.
Is entity being used in a different?
Mr. Chairman.
Yes, sir. Please.
This has been drafted to track, just sort of looking through the language that's in the Georgia Open Records Act. And so again, I remember from having had to deal with this a couple of years back when we were dealing with the Open Records Act when I first got here, and then also serving on House Judiciary. I mean, that maybe we should be using a different definition, but this is because the feds use a different definition. This is the definition we use.
Okay. Okay. Well, at the proper time, if we need, if we feel like we need to make a change, we can do that in the form of a amendment. You're good?
Again, I just wanted clarity on that.
Okay. Senator Jackson.
I'm out.
You done? He's done. Any other members of the committee have a question or comment for the author of the bill? Okay. Thank you, Senator. Yeah, we've got a few folks signed up to speak. And to those of you, Mark, where are you? Go ahead and start there. I'm going to, I want to keep these as brief as possible. If you just state your name, the organization you represent, and your position as succinctly as possible. And for those of you who haven't seen me run a meeting before, I will cut you off, and we will move on. We all have other committee meetings coming up, including myself at 4 o'clock. I've already spoken longer than I planned to, so please be brief. Let's get to the point, and let's get the business of the people of Georgia done. Thank you. Fire away.
Mr. Chairman, members of the committee, my name is Mark Wall. I'm chairman of the executive committee of the Georgia Chapter of the Sierra Club. And on behalf of our 10,000 members, I'm here to oppose this legislation. You may recall back in 2005, the Senate was actually the body that stood up for the people of Georgia and defeated House Bill 218, the Economic Development Secrecy Act. And the House said they were going to bring it back. So I'm disappointed to see it in the Senate. But at any rate, our concerns are the same as they were in 2005. We've got examples. I've got all the files here of the indictments of the COP, BMC, 31 felony indictments. I think that's Exhibit 1 for what happens when you don't have open meetings or the members are not even allowed to look at their records if they're cooperative. And I commend the Chairman Mullis for trying to cut out over 900 local development authorities. My experience has been fighting local development authorities who thought that economic development was landfills, medical waste incinerators, sludge dumps, dirty coal plants and that sort of thing, which we don't really think are the jobs we need to be looking for. But I've got various deed records, self-dealing and so forth from various local development authorities. But I won't go into that because I believe we're trying to exclude those local development authorities, which would be a good first step. I was troubled by that language about private person or entity, and I noticed in the last sentence there's not even private before person. So I would hope we could come up with something that makes it clear that we're talking about who we're talking about here. And really, I think the best thing to do would be to put in language making it clear that this does not include any local economic development authority, whether created, they're created by 3 ways in Georgia, created by a constitutional amendment or by ordinances adopted pursuant to the Constitution or by local legislation. So if we could specifically get those out of here, it would be great. I've got the amendment from 2005, sponsored by the Senator from the 16th, Senator from the 19th, and others, Senator from the 21st, which goes to our concern about these facilities and the permitting. You remember back then in 2005, we excluded components of programs of economic development that consist of solid waste, hazardous waste, or medical waste facilities, facilities for the disposal of sewage sludge or the handling of radioactive material, or electrical plants having a generation capacity of more than 25 megawatts. We think the folks need to be aware of this sort of thing. Or any application for a permit from the EPD, the DNR pursuant to Title 12, or development of any, or implementation of any comprehensive plan. And it makes plain that zoning decisions, components of programs, any permit application or comprehensive plans are excluded. So I think this is a fine amendment y'all have back in 2005 and commend it to you. The trouble is that information after the fact is not helpful if you're fighting some of these bad ideas, and I hope we can make it plain that the local economic development authorities are cut out. And I personally spent over 5 years fighting an authority of the state of Georgia, the Georgia Hazardous Waste Management Authority. I'm delighted that this legislature abolished the Georgia Hazardous Waste Management Authority. Of course, it had eminent domain power, and tried to locate a facility for hazardous waste for all across the country to come to my part of the state. So this is awfully broad. I understand Senator Mullis' concern, but it appears to me that if this problem with just us in West Virginia, that Georgia and West Virginia have, ought to be rectified some way besides including all these commissions, public corporations, authorities, and so forth. So I hope you all can narrow this down if you feel like you've got to help us in some way.
Thank you for your comments. Any questions? Concerns? I'm sorry, Senator Fran.
Mr. Chair, thank you. The way I read the language here, the definition of governmental agency, the only authority that's included in here would be a state authority. So that was a concern I had when I looked at the bill. So a local authority, for example, the Cab Development Authority, where I live, would not be included in the term government because all of these words after the words after a state, these are all state groups he's talking about. So local authorities are not included in the definition of a government agency, unless I'm reading this wrong, but I don't think so.
Well, actually, I'm concerned about the state authorities. We have many more state authorities than you might be aware of. I'm glad we've...
No, I understand, but I thought you said local development authorities, unless I misunderstood your testimony.
That's correct. What I was concerned about was, are we making sure that they're actually excluded here? Because like I said here in the last sentence, we leave out the private before the person. And as y'all were just discussing, I'm really not sure if we're just talking about the private entity, the applicant, whoever's trying to come in here. And I really think we need to just specifically exclude those development authorities, those local development authorities, to make it 100% plain.
Okay, yeah, I guess legislative council, I just read that they were talking about state authorities, and the local authorities did not fall under this code, under this section.
Well, I'm not sure what all state authorities involved in economic development, but I mean, we've got, this is awfully broad, is what I'm saying. This is Stone Mountain Authority. I mean, we've got all kinds of authorities that we wouldn't want to start having their meetings with open records on too. If you're in public interest, of course, also. You said it was making that decision, huh?
Thank you, Mr. Woodall. No more questions. Jim, you want to come up?
Thank you, Mr. Chairman. My name is Jim Colstead. I represent Common Cause Georgia, and it's my goal today to win the brief contest in speaking. We, Common Cause Georgia, opposed 218 in 2005, and we oppose this language and this bill as well. We're very proud of our open records and sunshine laws, and we want to remain, despite the bad weather today, the true sunshine state of the South.
Thank you, Jim. Bob Simmons, it looks like. And Development Authority of Fulton County, I believe.
Yes, sir. Thank you, Mr. Chairman.
Absolutely. Thank you for being here today.
Thank you. I want to make 5 points very, very quickly, discussing the need for confidentiality. The word of a company's potential location could cause the employees at the current location to impair productivity, spread false rumors about jobs, spread false rumors about relocations, who may lose their job, who may be transferred, who may be ripped up from their local community. So being able to keep what's going on from that happening is something that we need to do from a confidentiality standpoint, thinking about our client. Second thing, there have been several anti-confidentiality reports touting locations of dirty or unsavory company locations. I've been a professional economic developer for over 30 years, and I am quite proud of the projects which I have brought to the communities that I serve. And I do not deter from taking my family down a particular road or in a location and showing them the pride that I have in being able to locate clean industry, good jobs, good paying jobs to the state of Georgia. Finally, Georgia has had competitors file open records requests, as Senator Muller said, and they read our playbook. That's tantamount to the coach of a football team taking his playbook and giving it to the opposing coach on the Saturday morning before the Saturday afternoon game. And this bill is not about hiding anything. It's merely delaying the release of information until the project is resolved, whether the project comes here or the project does not. And Senate Bill 159 adds a much-needed tool to our economic development toolbox. State of Georgia is a very, very definite competitive disadvantage with states not only in the southeast region, but we're in a global market and we compete against foreign countries which have incentives and which have confidentiality throughout their projects. Thank you, Mr. Chairman.
Thank you, sir. Thank you, sir. We appreciate your testimony. We have no questions for you. Mr. White, Henry County Development Authority.
Good afternoon, Mr. Chairman, and members of the committee. Don't have a lot to add. I am a local economic developer. I also have the distinction of being the chairman this year of the Georgia Economic Developers Association, which is our statewide economic development group. We have a non-lobbying policy with the organization, but we are very keen on helping to shape public policy as it relates to economic development. So project confidentiality has been one of those items that's been on our agenda for quite some time, was on our public policy agenda this year prior to the beginning of the session. So it's not something that's specific to this bill that we've dealt with, but it's an issue that we've all had to deal with. You've heard from Senator Mullis, Bob Simmons, basic comments. I do have to admit that I am a development authority executive director. I've got to figure out now, in light of the comments by the gentleman from the Sierra Club, that I've got home and explain to my 85-year-old mother that I'm not maybe I could tell I'm a pornographer or a dog fighter or something like that, not a development authority person. But I can seriously address the same things. I've been in economic development for 26 years and local economic development level for almost 16 years, and we never brought in a project that was illegal, improper, or that was not protected by all the safeguards, zoning, and other issues that we have. From our perspective, it is a confidentiality issue. It is a competitive issue. You've heard about the questions and concerns about the premature release of information and the detrimental effect that it can have on a project. There are numerous examples of that having happened in the past. This is not about hiding information from the public. This is not about the right of the public to know and freedom of information. It is, as Bob Simmons said, I think very well, this is about delaying the information until such time as the decision has been made and the project moves forward. Senator Mullis noted again that there's nothing that is anticipated, I think, in this legislation that deals with anything that would not be available to the state. Legally, there are many safeguards that relate to proper zoning, permitting, and other issues that would preclude the negative influence of projects that are coming in. So I think it is important to note that the local development authorities have been removed from this discussion. I think that just clarify the issue and perhaps reduce some of the concerns. Local development authorities are a very key part of the economic development community in the state of Georgia. You can't deliver the local incentives and many of the state incentives without the participation of the development authority, including things like REBA grants, Henry grants, and those types of things. So local development authorities are not the enemy, and we don't seek to be, but we do seek to be team players and work within the framework of supporting our state economic development agencies. And we think this is something that would assist the state and be more competitive.
Thank you, Mr. White. We appreciate your testimony. Questions? Thank you so much. Jim Martin is here from Stevens County. Oh, I'm sorry. Jim? So you're here to work on City Budget.
Thank you, Mr. Chairman.
See you again.
Try not to repeat the points made by my predecessors. Let me just narrowly focus on one item. It's been alluded to the fact that Georgia's being asked to play with its cards face up. And that's certainly a competitive disadvantage in any sport that you're playing. In economic development, it's too serious to be considered a game, though. It's something that aspirations of all of our citizens are based on the ability that Georgia has to recruit new business to industry and encourage existing industry to expand. The point I want to make is that citizens they deserve our best efforts. And if we have to play our cards face up, if we have to reveal our playbook in advance, then citizens are not going to get our best efforts. This is about protecting the negotiation process. This is about resolving challenges and opportunities up front, and then still allowing plenty of time for proper public review on the backside. So I would urge respectfully that this board, this committee, and then the full Senate and House support this Senate Bill 159.
Thank you, Mr. Martin. Any questions?
Mr. Chairman, at the appropriate time, I'd like to recognize and make a motion.
Okay. We'll get there at the appropriate time. Thank you, sir. Mr. Rayner, do you have anything to add?
Mr. Chairman, David Rayner with the Georgia Chamber of Commerce. We at the Chamber do believe we should be doing everything to create jobs and make Georgia more competitive, and we believe that Chairman Mullis's legislation does just that. So we would respectfully request your favorable consideration in supporting the bill.
Thank you, Mr. Rayner. We all know who you are, know your organization. Of course, if we don't know who you are, that's your fault.
That's right.
You're doing a fine job. Mr. Barnes.
Mr. Chairman, members of the committee, I'm Glennis Barnes with Georgia Power. We want to speak in support of this legislation as well because we have a big economic development arm at Georgia Power, and we work on a lot of projects. And in the last 2 years, we had $4.5 billion in investment in the state and projects that we work with directly located here in the state of Georgia. And we just want to speak in support of this. And I also want to say, reiterating what he said, because of the non-disclosure agreements and that sort of thing. A lot of projects have gone to the wayside here in the state of Georgia because of that.
Thanks, Glenn. We appreciate it. Okay, I think we've got Senator Stoner. I'm going to let you speak to.
Mr. Chairman, I'd like to make a motion for committee substitute concerning line 3 on page 2, line 33, excuse me, on page 2, where it says this paragraph, comma, with an insert private between A and person.
Okay.
To correct that.
Okay. Anything else? Okay. We have you do that in form of motion. Okay, we have a motion and a second. All those in favor, please signify by saying aye.
Aye.
Those opposed likewise. Motion carries. Bill passes by substitute. Thank you, Senator Moss. Next item on the agenda, Senator Jackson has a resolution.